Any adjournment request? Daily list for admission, item number 1.
Legal Aid Council
Yes. First comment.
heard Mr. J. Das, Learned Legal Aid Council, for the accused appellant and MS Abel, Learned Additional Public Prosecutor for the respondent number 1, State House. Full stop. This criminal appeal under section 415 within bracket 2 of the Bharatiya Nagarik Suraksha Samhita 2023 is preferred against a judgment and order dated 10/6/2024 passed by the Court of Learned Special Judge within bracket POXO.
Please, Your Lordship. Lord,
Hmm.
appeal against conviction, Your Lordship.
In this criminal appeal
Under section
is
3.
directed against a judgment and order dated 15/9/2023 passed by the Court of Learned Additional Session Judge Thugri within bracket a trial court in sessions case number 160 of 2018. First up, by the judgment and order dated 15/9/2023, the accused appellant has been
Life imprisonment.
has been convicted for the offences under sections 302, 447, 324 of the Indian Penal Code. Full stop. For the offence under section 302, the accused appellant has been sentenced to undergo rigorous imprisonment for life and to pay a fine of ₹5,000, in default of payment of fine, to undergo rigorous imprisonment for another 3 months. Full stop. For the offences under section 324 IPC and section 447, IPC, different terms of sentence have been imposed. Full stop. It has been ordered that all the sentences are to run concurrently. Full stop. The criminal appeal is admitted for hearing. The case records of sessions case number 160 of 2018 be called for. Issue notice, return available in 4 weeks. As MS Begum appear accepted. Respondent number 1, the accused appellant shall take steps for service of notice upon the respondent number 2 by registered post with AD within 3 working days from today. Release the case after 4 weeks.
Much obliged. Item 3 for orders. We have received a paperwork, Lordship.
Ready?
Ready for
Hearing.
Ready for hearing.
Mr. D. Talukdar, Learned Counsel for the appellant in 4.
In item number 4.
Mr. A. Ganguly, who is for 5?
5. Nothing.
Amicus. A.
T.
Ganguly,
T. Begum.
Learned Amicus Curie for the appellant in 6. And MS B. Bhuyan, Learned Senior Counsel and Additional Public Prosecutor assisted by MS M. Chakravarti, Learned Counsel for the respondent number 1 are present. Post of Learned Counsel for the parties have submitted that parties have received a copy of the paper book. Post of they have submitted that as the paper book is ready, the appeals can be listed for hearing. Post of in view of above submissions made by the Learned Counsel for the parties, list the appeals for hearing in due course.
Lordship, counsel.
Maybe after puja vacation, because they are inside.
Item number 5 is absent.
They are inside, so maybe after puja vacation.
T. Begum
The-
for R5.
Hearing list will come. Even early also, not possible.
Not-
Five council is not there.
We have not recorded.
So registry may be directed
Oh.
to prepare the paper.
Heard Mr. O. Oscar, learned counsel for the appellant and MS B. Bhuyan, learned additional senior counsel and additional public prosecutor for the respondent number 10, state of Assam. Post of Mr. A. Ahmed, learned counsel, has submitted that he has entered appearance on behalf of the respondent number 1 to 9 after service of notice. Post of Para. Records received
And there is.
as the case records of sessions case number 58 of 1998 have been received, office to take steps for preparation of the paper book, place the case up.
Dated 22/5/2024, whereby the appellant was convicted for imprisonment of life under section 302, Lordship.
Okay, this is the first time you are
Lordship,
moving.
Lordship,
Okay. Heard Mr.
P. Das, Lordship.
P. Das, learned counsel for the applicant appellant. And MSA Begum, learned additional public prosecutor for the opposite party number 1, opposite party, state of Assam. First of, the instant interlocutory application is preferred. Under section 389 within bracket 1, Code of Criminal Procedure 1973, seeking suspension of the execution of the sentence passed against the applicant appellant and for his release on bail, to stop. The applicant as an appellant has preferred. Oh. Mr. Counsel,
Lordship,
appeal is not yet admitted.
not admitted. Today is the first day, Lordship.
First time.
First day, Lordship.
So I has been listed ahead of the appeal.
Lordship.
Offense,
302, Lordship.
we admit it.
Admit-
Otherwise directing again for
Then again,
admission.
admission.
Heard Mr. P. Das, appeal only here. Learned counsel for the accused appellant and MSA Begum, learned additional public prosecutor for the respondent number 1, state of Assam. Post of. The present criminal appeal is directed against a judgment and order dated 22/05/2024 passed by the Court of Learned Sessions Judge Baksha Musalpur Trial Court in Sessions case number 53 of 2019. Full stop. By the judgment and order dated 22/05/2024, the Learned Trial Court has convicted the accused appellant for the offense under section 302, IPC, and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 2,000, in default of payment of fine, to undergo simple imprisonment for another 6 months. Full stop. We have perused the memorandum, contents of the memorandum of appeal, and the criminal appeal on consideration, the criminal appeal is admitted for hearing. Issue notice, let the case records of sessions, case number 53/2019 be called for. Issue notice returnable in 4 weeks as MS Begum, learned additional public prosecutor, has appeared and accepted notice on behalf of the respondent number 1, state of Assam. Issuance of formal notice to the respondent number 1 stands dispensed with. Extra copy. The accused appellant shall take steps for service of notice upon the respondent number 2 by registered pursuit AD within 3 working days. List the case after 4 weeks. Issue notice. Issue notice returnable in 4 weeks. As MS Begum, learned additional public prosecutor, has appeared and accepted notice on behalf of the opposite party number 1, state of Assam. Issuance of formal notice to the opposite party number 1 stands dispensed with. Extra copy within 3 working days. The applicant is to take steps for service of notice upon the opposite party number 2 by registered pursuit AD.
Lordship.
the objection to be filed on the learned additional public prosecutor uh, is to file objection to the instant application on or before the returnable date.
Obliged goods.
Item 12,
Offense.
May I please, your lordship? My lord, a criminal appeal has been filed, my lord, against the imprisonment for life, my lord,
Heard.
and 29 days delay.
Mr. A.K. Ajad, learned counsel for the applicant appellant, NMS A. Begum, learned additional public prosecutor for the respond number, opposite party number 1, State Vasa. Full stop. The instant application under Section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 29 days, which is stated to have occurred in preferring the accompanying appeal, criminal appeal. Full stop. Para. The accompanying criminal appeal is preferred against a applicant 3.
My lord,
Okay, applicants is preferred against a judgment dated 28/3/2024 and an order on sentence dated 30/3/2024 passed by the learned additional sessions judge Udalguri, Assam, within bracket trial court. In sessions within bracket Roman capital 1 bracket close, case number 123 of 2018. Close stop. By the judgment and order, by the said judgment and order, the applicants have been convicted for the offenses under section 341, 323, 302, IPC, read with section 34, IPC. And they have been sentenced under section 302 IPC, read with section 34 IPC to undergo rigorous imprisonment for life and to pay a fine of 5,000 each, with default stipulation, full stop, for the offenses under sections 341/34, IPC and sections 323/34 IPC, different terms of imprisonment have been passed against the appellants. Full stop. We have perused the statements and averments made in this application, more particularly, paragraph 3 thereof, wherein the appellants have explained the reason for preferring the accompanying delay after 29 days beyond the period of limitation in preferring such a criminal appeal. Full stop. Para. MS Begum, learned additional public prosecutor, has submitted that since the appellants are found guilty of the offense under section 302 IPC and they are undergoing sentence says of life imprisonment, comma, interest of justice would be better subserved if the accompanying appeal is heard on merits. Full stop. Having gone through the reasons given in the application as regards the delay, we are of the considered view that the appellants have been able to explain the reasons for delay, showing sufficient cause in preparing the appeal, criminal appeal beyond 29 days. Full stop. Any view of the matter, comma, see, as the appellants are undergoing life imprisonments, comma, interests of justice will be better served if the criminal appeal is heard on merits. Accordingly, the instant application, the period of delay of 29 days in preparing the accompanying appeal is condoned and the instant application stands allowed. The race to list, register the connected appeal, accompanying appeal, and thereafter comma to list the appeal for admission. I don't go to.
Highly obliged.
For hearing item number 13,
Lordship, IA will be filed after receiving of the LC.
I is there already, it will be numbered.
Objection after receiving of the LC, file after file.
Let it be registered,
Yes, sir, that is,
Obliged.
not yet born.
that is, Lordship, right?
I have to do one register accompanying appeal and the connected interlocutory application will be. It was register the accompanying appeal and the connected interlocutory application. A last thought. Yes. Ready? Yes.
Yes, your lordship. 302, lordship, life imprisonment. Lordship will find a FIR at page 4. Small FIR, very short. It was lodged on 26/11/2018. So humble submission is that at about 8:30 PM today,
Hmm.
that is on 26/11/2018, the below mentioned accused had an altercation with my mother, Sri Lota Boro, and then killed her by hacking with a dao. Learning about this, I inquired about the same and came to know about the incident. I therefore pray to you to take necessary action after investigating into the matter. So informant is basically the son of a victim, but informant was staying separately as the victim was married to somebody else, not his father. Now lordship will find the deposition of the complainant at page 8. My name is Niranjan Boro. I know the accused Jagat Das. Sri Lata Boro is my mother. My mother used to reside with the accused separately. I reside at a distance of 1.5 kilometers away from my mother. So the two houses are 1.5 kilometers away. The place of occurrence and where the informant is to stay. Prior to the incident, I heard that the accused used to pick up quarrel with my mother. On the day of incident, that is on 26/11/2018, at 8:30 p.m., time may be noted, not 8:30 p.m., the neighbor of the accused informed me over the phone that the accused was beating my mother. Then I, along with my friend Khoghen Boro, came to the house of the accused and found the house locked from inside. I knocked at the door and asked what is happening. Then the accused asked not to enter in his house and threatened to kill if anybody entered into the house. There was desk in the veranda of the accused, and standing upon the said desk, I noticed inside the house through the ventilation and had seen my mother lying dead upon ground, and the accused with a dao was sitting near my mother. Seeing the incident, I came outside the boundary and over phone informed my villagers. Though some neighboring persons came there, though we asked the accused to come out, but he refused and said that only after the arrival of police he will open the door. Thereafter, some people along with police reached there. Police asked the accused to open the door. Accordingly, he, opening the door, came out with a dao in his hand. Police apprehended the accused and took him to the police station. Police also took the dead body of my mother for post-mortem examination. I had seen cut injury over neck, near ear, cheek, finger of my mother. Police seized the dao. I lost the FIR. Exhibit 1, Exhibit 1.1 is my signature. Exhibit 2 is the scissor list by which police seized the dao. Exhibit 2.1 is my signature. Material exhibit is the dao. Cross-examination part also. After 10-15 minutes of receiving information over phone, I reached the place of occurrence. The house of Niranjan Mohilari is situated near the house of the accused. I do not know the other neighbor's name. I received the information from a member of the house of the Niranjan Mohilari. Now, let's see the source, basically the whole story start running from the information. Now, the informant was not examined. Who has actually informed? He or she, I don't know. It was not examined. Though I know the villagers of the accused village, but I do not know the names except Niranjan Mohilari. Niranjan Mohilari is the neighbor. And from somebody from his, family, supposedly intimate. It is not a fact that the relation between the accused and my mother is good. It is not a fact that my relation with the accused and my mother was not good. Regarding money and land quarrel took place between the accused and my mother. It is not a fact that regarding money and land, there was no quarrel between the accused and my mother. After I informed the villagers about the incident, about 12-15 persons gathered there. It is not a fact that before police I stated that hearing about the incident, when I went to the house of the accused Jagat Das, the villagers of the village of the accused gathered there, and accused Jagat Das from inside the house scolded the villagers and threatened them to kill. It is not a fact that on that day nobody informed me, and I also did not go to the house of the accused. It is not a fact that before police I stated that I was informed that Jagat Das, by committing murder of my mother, was inside the house by closing the door. I had seen my mother accused inside the room through torchlight of my cell phone. So inside it was dark, supposedly. So he used his mobile phone, and with the torch of the mobile phone, he he stated that he has seen the incident. It is not a fact that I had not seen my mother and the accused through the torch light of mobile. It is not a fact that I informed a known police officer to me about the incident, and as per advice, without knowing about the actual incident, I lost the FIR. When police called the accused to come out, and accordingly the accused came out with a dog. At the time, Manoj Boro, Pavan Boro, and some others were present. These Pavan Boro, Manoj Boro, they were not examined. It is not a fact that I had not seen the dead body of my mother. I do not know the contents of the seizure list, Exhibit 2. It is not a fact that I knew nothing about the incident, and today I deposed falsely. So, Lordship, before I take your Lordship to PW 2 and 3, I will directly take your Lordship to PW 5 at page 16, because PW 5 is the friend Khoghen Boro, who was supposed to be with the informant. Page 16, your Lordship. My name is Khoghen Boro. I know accused Jagat Das. I do not remember the date of the incident. On the day of the incident at about 7-8 p.m. So the time may be, Lordship may kindly note that about 7-8 p.m. when I was on road in front of my house. So he was on road in front of his house. So his house is actually near the house of the informant. It's in a different village away, 1.5 kilometers away. My sister Himani Boro informed me that Alopi Mahilari, daughter of Niranjan Mahilari, reported her that there was some halla in the house of the accused, and thereafter the situation was quite silent, hence asked me to see the matter. Now, Alopi Mahilari is the daughter of Niranjan Mahilari, who is the neighbor of the victim and the accused. So 1.5 kilometers away. So now he says, Khoghen Boro says that he was in front of his house, 1.5 kilometers away from the place of occurrence. Then Alopi Mahilari, daughter of Niranjan Mahilari.
They are missing of the word mobile.
That's it.
Maybe it is by mobile.
But there is no mention about mobile.
But all these information, these are not material points.
No, I mean,
These are
in,
non-material points.
no, in this case, lots of information is material. I in my humble service, because that the whole thing came, it started from the information source. How information has been received, when the information has been received, and who has given the information. Because this informant was not there at the point of time. Now, my sister Himani Boro informed me that Alopi Mahilari, daughter of Niranjan Mahilari, reported her that there was some halla in the house of the accused, and thereafter the situation was silent, hence asked me to see the matter. Then I, along with Niranjan Boro, the son of Lota Boro, went to the house of the accused, and Niranjan Boro called his mother as Ma, but not finding response, knocked at the door. Then Jagat Das replied that his mother is not available at home. Then, on asking Jagat Das by Niranjan Boro where his mother has gone, Jagat Das only replied that she is not at home. Accused Jagat Das threatened us to kill if we tried to open the door. Then Niranjan Boro, standing upon a bench which was in the veranda, peeped through the ventilator inside the room and saying that, "Hey Bhagavan, get down from the bench." Then I, peeping through the ventilator, had seen blood and body of the Lata Boro covered with a cloth. The description about the incident clothes. Then I peeped through the ventilator, had seen the blood and the body of the Lata Boro covered with a cloth. Now, from his statement, we do not know how Niranjan Boro and like Khoghen Boro got together. From his statement, at least. Then, seeing the incident, out of fear, I and Niranjan Boro went away. Many persons gathered there, and on being informed, police also came and apprehended the accused Jagat Das along with the dao in his hand. Police seized the dao. White Caesar list exhibit 2 and exhibit 2 is my signature. When the dead body was taken for postmortem examination, I was present there. And this Alopi Mohilari was also not examined. Who has intimated or informed Niranjan Boro's sister, then Niranjan Boro's, Khoghen Boro's sister, then Khoghen Boro's sister intimated Khoghen Boro. The cross-examination part here also. On receipt of the information, I reached the place of occurrence after about half an hour. Daughter of Niranjan Boro is friend of my sister. The house of Niranjan Boro is near my house. Though there was no light outside the house of the accused, but inside the house bulb was lighting. The house of the accused consists of 2 rooms, and from the light of other room, I had seen the blood and body of the other room. I and Niranjan Boro did not use any torchlight or mobile light to see the incident. So there is some contradiction about the stories of these 2 people who, they were the first people who went there together. And there are some, in the story itself, there are some contradictions. Seeing the incident, I and Niranjan Boro came out from the boundary and informed the neighboring people. About 50 persons gathered there. Pavan Doimari, APSU Secretary Manoj Boro, and many others came to the place of occurrence. On that day, a meeting was convened in honor of successful candidates of APSC, wherein many government officers present. And after the incident, taking advice of the villagers, lost the FIR. So these are some additional facts which has been added by Khoghen Boro. These were not stated by Niranjan Boro, the informant. And this Pavan Doimari, APSU Secretary Manoj Boro, they were not examined. So these people were there at the place of occurrence, supposedly, but these people are not examined.
Requirement, is there any requirement?
This is, as a sane police officer, sane police prosecution officer, I would like to have their statements recorded if they were present there. It may not be lordship. If there are 100 people.
If one goes by the Evidence Act, not the number.
Yes,
of
yes,
witness.
correct. That's absolutely correct. Also. If there are 100 people, I may not be.
100 will be examined, no? 50 are there.
Not necessary, not necessary at all.
If that witness is a witness to a very significant thing,
Correct.
when he was not examined, then it will go against the prosecution. But
Yes, yes.
mere bystanders,
Yes, yes. No, only thing is that like it has come in a statement.
they are
that-
bystanders,
that lordship, their names have been specifically named
named.
in the statement. And some people who were not named in the statement, they have been examined. So this, if they have been named and they have not been examined, then usually, generally, they should have been examined. It is not a fact that we informed the matter to police and other officials of administration, and as per their instruction, we lost the FIR without knowing the actual fact. I do not know in which parts of the body the deceased sustained injuries. Today, I have seen the seized dao. I had seen the seized dao in the hand of the accused on the day of the incident. It is not a fact that I had not seen any dao in the hand of the accused. It is not a fact that I did not go to the place of occurrence. On the day of incident, I did not hear any alarm of Lota Boro. It is not a fact that I did not state before the police that I, along with Niranjan Boro, son of Lota Boro, went to the house of the accused and Niranjan Boru called his mother as Mama, but not finding any response, knocked at the door. Then Jagat Das replied that his mother is not available at home. Then on asking Jagat Das by Niranjan Boru where his mother had gone, Jagat Das only replied that she is not at home. Accused Jagat Das threatened us to kill if we tried to open the door. Then Niranjan Boru standing upon a bench which was in the veranda peeped through the ventilator inside the room and saying that, "Hey Bhagavan, get down from the bench." Then I, by peeping through the ventilator, had seen the blood and the body of Lata Boru covered with a cloth. It is not a fact that before police I stated.
What is the purpose of this,
Lordship?
this quote unquote part? It appears ditto with his
Yes.
examination in
It's
chief.
because of the storytelling, about the
No,
incident.
this, why this quote
Because
unquote?
that I would not be able to answer, but like, I think the storytelling is, little bit different than the storytelling by
No,
the.
no. This has been marked. This
Already
portion has
there.
been marked.
Yes,
Now I compared with his
Same. Lord.
evidence in chief. This marked portion is from the evidence in chief.
Correct.
So under what law this is done? We know that previous statement is not evidence in chief. Previous
Correct.
statement is previous police statement.
He's talking about, it is not a fact that I did not
A
state
state
before the police.
police.
So try just.
Otherwise, this quote unquote part
Yes,
is
yes.
exactly
Exactly,
similar to
yes.
evidence in chief.
Exactly.
But if really
It would have been quoted from that police.
once a
whatever-
police statement,
Correct.
okay, let us assume it to be marked. Whether I was confronted with,
No.
then nothing. No value.
Only the probably because of the storytelling is little bit different.
No
That's why
value,
they
that
have-
is.
They have probably, but it has not been picked up.
This exercise is
I understand. Yes. Then.
wastage.
Then let's say after about 2 days, police recorded my statement. On the next day of the occurrence, police obtained my signature in the seizure list. I do not know the contents of the seizure list. Police only said that regarding murder of Lata Boru, I was cited as witness. This may be Lordship may note.
But what has emerged clinchingly, and their evidence is not discredited from PW1 and PW5, that you were inside the room and the house was locked and the body of your wife was inside the house. No cross-examination, no plea of alibi, you were not there, not somebody else was there. So these three things, that their PW1 and PW5's presence at the earliest point of time was not denied at all by way of cross-examination, no plea. Secondly, that you were inside the house, that is not denied. That the body of the, in a dead condition of your wife was there is not denied. Then fourthly, that the house was locked, that was not denied. Police came, you came out, that is not denied.
Yes, that is there.
You have not contested that. You have not confronted these two witnesses on these aspects.
Nothing
You have
is-
quoted or evidence in see whatever, but the crux of the matter is that on these 5 points, you did not take any plea.
Nothing. Absolutely. So there's nothing on record. Nothing on record. But this thing is Lordship, as far as Lordship seizure list is concerned. So he admits that like seizure list, actually the signature was taken after 2 days.
On 2 days.
When it was seized, it was not, his signature was not taken. And he is not aware of what is there in the seizure list.
But all defects in the investigation may not go against the prosecution,
Absolutely.
may
Lordship,
not create the
understand.
dent.
I understand.
But these two appears to be otherwise Alopi Mohiliari, daughter of Niranjan Mohiliari, informed the sister of PW5. And PW5 has been informed by his sister. Niranjan Boro is his neighbor. And both of them went together. Quite plausible.
Yes, quite possible, but like Lordship, as far as Niranjan Boro is concerned, he said like he intimated Khoghan Boro.
He intimated.
And Lordship neighbor, then no, Lordship, that's correct. I mean, then
I-
I along with Khoghan Boro.
They were resident of another village.
Another
Both
village. Both of them went-
PW5 and 1. Somebody, Niranjan Mohila, is a neighbor of the accused.
accused.
His daughter informed the sister of PW5.
Correct.
And sister of PW5 informed PW5.
Correct.
And PW5 informed PW1.
No, that is not the story.
It is there.
That is not the story. Lordship.
It is just there.
Because it says that Niranjan Boro called as independent call from the neighbor of the accused and this thing. Page 8, your Lordship.
Oh, this PW5,
Hmm.
PW1,
Yes. PW1 says that like, he received a call
then
from the
adds up that adds up.
on
That I resided this on the day the neighbor of the accused
Correct.
informed me that he did not fill up all this. He said in a shortcut.
he says that like he
But
received a
that
phone call.
adds up the story. This
It may happen, Lordship. I don't know. I can't deny
may
it.
happen.
It
It
may
is
happen that like
not implausible.
it's possible that like one call went directly to him and like then like daughter of that neighbor of the accused again intimated this guy's this person's sister.
This is not disbelievable.
This is fine, Lordship. I'm not on that. But like thing is that Lordship, one thing it has come in the examination part only. This person is actually a non-Boro person. Lordship, I'll have to place the facts. That's why I'm placing. That in that particular village and in that locality, this accused Jagat Das is a non-Boro person. Only non-Boro person is staying there. He married to a Boro lady, and like this place is basically inhabited by the Boro population. Why I'm saying that, Lordship, because there was a plea taken by this accused, saying that like when he came back from his work, he found this lady dead inside. That was the answer he has given under 313. I'll come to that, Lordship. Now, Lordship, we'll go to the other witnesses' statements.
Hmm.
Page 11, your Lordship will find. Page 11, this is PW2. His name is Nityananda Das. Now, Nityananda Das, I don't know Lordship, how he has come. I know the accused Jagat Das. The incident occurred in the month of November 2018. On that day, I went to Misamari police station. I saw the accused Jagat Das at the police.
He visited police station. Otherwise, he is Sarkari Gambura of another village.
Yes.
He
This is Pakari Gaumara.
he is neither for the prosecution nor for the defense.
Yes. So like his statement has been recorded. The prosecution found him to be a very important witness.
A well-trained IO.
Yes, Lordship. He very well trained. So there is nothing in his examination, Lordship. Still, Lordship, I'll just read out the cross-examination part.
Yes.
My house is at 25-30 kilometers away from the place of occurrence. I had not seen the incident. I am Sarkari Gauvura in Ramnathpur village, which is 25-30 kilometers away. The accused Jagat Das is not from my area. When Jagat Das made statement before police admitting his guilt, it was about 3:30 to 4 p.m. I do not know when the incident occurred. Police did not record my statement. It is not a fact that on that day, I was not present at the Thana premises. It is not a fact that police had not shown me any doubt.
Because of his third line statement, he before police told that he had cut his wife with a dao. At that time, I was present there. And this statement, police thought that will have bearing. But this is prohibited under section 25 and 26. But many of the IOs think that this kind of statement is
Are very
admissible.
important and
So
vital.
that is why he has come. Yes.
Then PW3, Your Lordship, page 12. Pradeep Kumar Boro. He is supposedly a neighbor again. I know the accused Jagat Das. He is my neighbor. I also know this is Lata Boro, the wife of the accused. The incident occurred in the month of November 2018. I always heard quarrel between the accused and the wife. On that day of the incident,
Mm.
I was at home. On that day, at around 7 p.m., Your Lordship, 7 p.m., the time has to be noted. At 7 p.m., Niranjan Boro, son of Jagat Das, informed me that Jagat Das had killed his wife. This is not possible either way, Lordship. I mean, if the incident happened, then that 7 p.m. timing is
No,
totally
no, but that is not material.
1 hour, Lordship.
There are 3 hours also.
Before 1 hour of
But
the occurrence, he intimated.
Substratum of the prosecution story is to be looked into.
I understand also. The son of Jagat Das informed me that Jagat Das killed his wife. Then I went to the house of the accused. At that time, some other persons also gathered there. When I reached the house of the accused, Jagat Das was raising halla inside his house. Then Niranjan Boro, the son of Jagat Das, told that his father is armed with a dao. Immediately, I informed police. So he has supposedly informed police, Lords. Accordingly, police came and apprehending the accused, took the dao from him. Thereafter, took the dead body of Lata Boro along with the accused. Cross-examination party, Lordship. My house is about 100 meters away from the house of the accused. I do not know the exact time of the time when the incident occurred. I had not seen the incident. As co-villager, I know the accused and the deceased well. Accused is third husband of the deceased. I do not know whether Lata Boro was drawing pension from her first husband Paniram Boro. Niranjan Boro is the son of the deceased through her second husband. I do not know about the relation of the deceased with the family of the first and second husband. I never had seen Niranjan Boro visiting the house of the accused. It is not a fact that I was not informed by Niranjan Boro about the incident. When I reached the place of occurrence, there was about 20 to 30 persons, including Manoj Boro, Hitesh Narzari, Amar Doimari, Ramprasad Boro, Pavan Boro, Pavan Doimari. I do not know who first saw the incident. So he's saying that he doesn't know who has actually seen the incident.
Neighbor,
Neighbor.
but your quarrelsome nature is mentioned.
Yes, that is there. Also. Along the police, no magistrate came. I had seen the dead body from a few distance, hence I could not say on which parts she sustained injuries. It is not a fact that the incident occurred at 8:30 p.m. So 8:30 p.m. he is also denying that it did not happen at 8:30 p.m. It is not a fact that on that day I did not go to the place of occurrence. It is not a fact that today I deposed falsely. The house of Niranjan Mohilari, Sonu Sargiari, Kamala Boro, Balin Boro, Khudiram Bora are situated near the house of the accused. When the police apprehended the accused, I had seen the dao. I could not say the exact length of the dao. The dao contains bloodstains. Today, I had not seen the dao before the court. Dao was not sent to the FSL, Lordship. It was not properly this thing also. It was not sent to the FSL. No matching of the blood, nothing like that. Then, Lordship, the another neighbor, the Niranjan Mohilari, PW4, page 14, Lordship. My name is Niranjan Mohilari. I know the accused Jagat Das. He is my neighbor. The incident occurred about 5 months ago at about 8:30 p.m. The accused often used to pick up quarrel with his wife Lata Boro.
So
On the-
two neighbors telling that quarrels
Some
used to
quarrel-
take place, used to take place. Yes,
On the day of incident, in the evening time, the accused had quarreled with his wife.
yes.
So this I do not know from where he has stated because next sentence Lordship will find on that day at around 8:30 p.m. while I was sleeping, my wife
He thinks that 8:30 is not evening.
Lordship,
He thinks that 8:30 is not even in evening. 8:30 is night.
night, yes.
So evening will be before night.
Little bit, obviously, little bit before this. Yes. On that day at around 8:30 p.m., while I was sleeping, my wife informed me that accused Jagat Das had killed his wife. So as far as the quarrel is concerned, I don't know from where he has got it. At least that particular day. Then I came out from home, and after arrival of police, I went to the house of Jagat Das. I had seen the dead body from a distance, but I did not enter the house where the dead body was lying. Though later on police brought out the dead body outside the house, but I had not seen the dead body from near. Jagat Das killed his wife with a dao. Cross-examination part here also. My house is just adjacent to the house of the accused. As at the time of the incident, I was sleeping, I did not hear any halla. I had not seen the incident. Accused Jagat Das had not threatened me or others to cut or set fire my house. Jagat Das was the third husband of the deceased Lata Boro. Since last 15 years, Jagat Das purchasing the land in his name near my land used to reside there with his wife by constructing a house there. I do not know about any dispute between the accused and wife regarding land and money. So he says there is no dispute, Lordship. He says there is no dispute about land and money. I do not know about the relation of Lata Boro with the family members of first and second husband. Prior to the incident, Niranjan Boro, the son of the deceased, had no relation with his mother Lata Boro. Later on says I do not know about the relations between the deceased and Niranjan Boro. So what kind of relation the mother and son was having, that was he was not sure. He didn't know about this. Our village is, lots of this is important. Our village is primarily Boro populated area. I do not remember who came to the place of occurrence. I do not know except Pradeep Boro. I went to the place of occurrence at around 9 p.m. Accused Jagat Das informed Niranjan Boro about the death of Lata Boro. So he says that accused Jagat Boro informed Niranjan Boro about death of Lata Boro. My family consists of 6 members. At the relevant time, we are all at our home. I only went to the place of occurrence amongst the family members.
His wife.
At first, my wife informed Niranjan Boro about the incident, and then knowing the fact, Jagat Das informed Niranjan Boro. So now, like Jagat Das informing Niranjan Boro, I don't know, Lordship, how it is. I myself did not hear making call to Niranjan Boro, but she reported me about that. That she has called Niranjan Boro. Maybe later on she has informed. So this place is a Boro populated area, and as far as like who intimated Niranjan Boro, how it has got to know, there is some contradiction in that. It is not a fact that at first my wife did not inform Niranjan Boro about the incident, and then knowing the fact, Jagat Das informed Niranjan Boro. On the very night, police recorded my statement. It is not a fact that Jagat Das and his wife prepared liquor at home, but both the husband and wife, after consuming liquor, used to pick up quarrel. He is denying this, Lordship. The house of Boneswar Wurang and Gandheswar Boro are situated near my house. The night was dark. I do not know the exact time of the incident. At present, the land of Jagat Das is lying vacant. I heard the whole incident from Niranjan Boro. The Lordship may kindly note this sentence. I heard the whole incident from Niranjan Boro. It is not a fact that as tutored by Niranjan Boro, I deposed today before the court. It is not a fact that on the night, neither I went to the police place of occurrence nor had seen the dead body. So after stating all this, Lordship, he ended up with saying that I heard the whole incident from Niranjan Boro.
Hmm.
PW5 Lordship, I have already read it. The Khoghen Boro, page 16. So page 18, Lordship. PW6 depends on the Boro. I know accused Jagat Das. I know this is Lata Boro, the wife of the accused Jagat Das. The accused was the second husband of Lata Boro. The incident occurred on 26/11/2018. On the day of the incident, in the evening, Niranjan Boro, son of Lata Boro, rang me and saying that his mother was murdered, called me to his house. Then I, along with 4 or 5 others, went to the house of the accused Jagat Das and remained outside of his gate. So they did not go to Niranjan Boro's house, though Niranjan Boro called him to Niranjan Boro's house. He directly went to the place of occurrence with 4 or 5 others. At that time, Jagat Das was inside his house. We waited for police. After some time,
This tallies with Niranjan Boro's statement. Seeing the incident, I came out outside the boundary and over phone informed my villagers. Not the villager of Jagat Das, he informed his villagers.
his villagers,
And these villagers are from PW1's village,
That-
Dipen Boro.
that's a different village.
He came,
So all these people are also like from the village of the informant.
no, Niranjan Mohilari is their neighbors.
Neighbors, yes.
He came, then the other one came, both 2 neighbors came.
Now this,
And this man is from the village of PW1.
yes, Lordship, yes.
He came,
yeah.
I along with 4 or 5 went to the house of the accused because at that time PW1 was in the
Place of occurrence.
place of occurrence.
Yes, Lord.
So he-
So they directly went there.
Yes, he directly informed over phone, inform my villagers.
Yes, yes.
Because he says except Niranjan, he doesn't know anybody. PW1 says.
Correct.
Mohilari, Niranjan Mohilari,
Mohilari.
he doesn't know anybody. Maybe he know by face, that is what he said. PW1 says, I know the
The next,
villagers, but I don't know them by names. It is normal. I know of persons from the nearby Para, but I don't know their names.
of the.
This happens.
That's it.
Yes. Anything? PW6?
Then like Lordship,
He,
the cross-section part, Lordship, I'll just read out.
otherwise he corroborates
He says the same thing, Lordship,
Same thing.
that
that accused came out of the house after arrival of police, and that too with a dao. That is all are saying.
That's all I'm saying. That all I'm saying.
And you are not disputing it.
I can't.
Core of the story is to be looked at first.
So there was a dog, there was a dead body, and there was the accused
was
was
you.
there. Accused was there.
And the house was locked.
It was locked. Now, like the accused, the defense story is that accused came from walking. Then he found the dead body inside, and then like he got scared, and like he thought like he may be killed, so he locked the door from inside. Then he was waiting if somebody comes, then like somebody stays free.
Any suggestion, defense plea? Anywhere like this? We have read up to PW5 and PW6.
I mean, only statement he says, only 313 statement. he says.
Defense, no setup. No story is set up like that.
No, no.
Then amicus cannot
No,
manufacture a story.
I understand. So only 313 statement.
When you
I was
read,
elaborating.
when you read 313, then you tell that. But
was
so
ela-
far defense story is
I
concerned,
was elaborating it. Lord.
through cross-examination,
Nothing.
none of such story has been
Nothing,
projected.
nothing can go. I'll just
At
read
least
out.
at least you should have set up a story.
Nothing was set up.
And even to come within exception, that was also not there. That sudden provocation
Nothing.
or sudden fight, nothing.
Nothing is there. Also. Only Lordship, like Lordship will kindly consider this.
You are implicated into 302, then life, there is no alternative. Suppose story is proved. But defense story is not there.
It's not there.
The core was not,
Now, only thing is.
core was not disturbed.
Only thing is that Lordship, there is little bit of doubt about the motive. Motive part, Lordship, I mean, whether the motive was there or not. I mean, that's prosecution could not bring in Lordship. The
But
motive.
quarrel, two neighbors.
Quarrel, two neighbors have stated, but like there is a defense witness also. There is a defense.
We'll see to that.
That
We'll see to that.
We'll
Let us complete PW6.
Yes, Lordship. PW6 Lordship, like the cross-examination part little bit, I'll just read out. Informant Niranjan Boro is my friend. See, all these people are his friend, Lordship.
Definitely.
Friend, we hail from the same village.
Ah,
Accused is a resident of adjacent village. The house of the accused is about 1 kilometer away
Correct.
from our village.
ah.
So far my knowledge, the area of the accused is resided is a Bodo populated area.
Correct.
There is only one SMS family, that is the accused. The informant is also a Bodo person. Kogen Boro is also a resident of our village. He is a Bodo person. Kogen Boro is younger than me.
Mm,
Misamari police station is situated in the middle of the house of the Jagat Das and our village.
mm.
One thing was, Lordship, like I was just questioning myself, Lordship. I mean, this police station actually located in between these two villages. So when this person, Niranjan Boro, Kogen Boro, and others, they got the information that somebody was killed, and like Niranjan Boro's mother was killed, and they passed through the police station, but they did not bother to inform the police station. They did not went to the police station. They did not go to the police station and did not say anything about this. I mean, I was just thinking whether, whether as a person, I would have informed the
Come
police.
to page 1.
Page 1. Yes, Lordship.
Para 5.
Yes, Lordship. A place of occurrence.
2 kilometers.
Yes, 2 kilometer, 1 kilometer. So like, it is in between, Lordship. I mean, as per
He
the
said,
in between. So like, I mean, Lordship, I am informed in one village, and like the police station falls
Now-
in midway.
yes, now there, this is a fact. As this cannot be, say, is situated in the middle of the house of Jagat Das and our village.
Yes, it seems, Lordship, they have to pass through the police station. So this is only a query came to my mind, Lordship. I'm just pointing out, because whether they could have probably intimated police before going to the place of occurrence. They didn't do so. And why they
Who?
haven't done so? Lordship?
Who?
Niranjan Boro, Khagen Boro.
See the stories of the prosecution that somebody from Niranjan Mohilari heard quarrel, then they thought something had happened. Informed the sister of PW5. Sister of PW5 informed PW5.
And,
5.
and
PW5 informed PW1. Then PW1 rushed.
no, the PW1 was informed by the wife of Niranjan Mohilari. That was the version of Niranjan Mohilari over the phone. But anyways, Lordship, whatever way, the information they got.
Where is the core material points?
No, yes, correct, Lordship. No, I mean,
These are not
yes. No, these are not absolute.
These are-
Like,
the core of the story. Now theory will come there from
I
there.
fully agree with your Lordship with that. Lordship,
So these are
incidental things, Lordship. Incidental. I'm just
whether it
pointing
has
out
dented the prosecution case. That is what.
some kind of infirmities, maybe some kind of doubt.
All infirmities will not do. But the
I mean-
core of the prosecution story that you were inside the house, the body was there, then these two were the first two persons to arrive and looked at through ventilator. Some said light, some said not light. That is one thing. And the house was locked. And you came out of the house with the dhow after arrival of police. These are not disturbed.
These
That
are
is
not
what I have found.
These are not disturbed.
Then what to?
These are not disturbed, Lordship. These are not disturbed. On,
Disturb one. These are all. And if
at least
everything
these
is accurate, that is the Supreme Court
at
saying.
least these
If
four-
everybody is accurate, then it is a case for doubt. Right. If everything is precision, they have said with precision 7:15. Everybody says then it is a case of doubt.
Yes, sir.
Then something is fully set up. But if that is the normal human conduct, that is what Supreme Court has said.
Yes, yes, yes.
Somebody says 7:30, but villagers, they are in the habit of saying approximate time according to their understanding. They go by sunset and so and so. That is what. So these timings, I don't think it is materially affecting the prosecution case to cut the matter short. Because I have seen this is a homicide, culpable homicide amounting to murder, the injury, post-mortem report. Absolutely. There is no doubt about it. How many? Chop wounds? 9. Now it is you who owes an explanation.
That is what Lordship, I am like.
106. Whatever is possible to be proved by the prosecution appears to have been proved.
Correct, Lordship. 106, he is supposed to say only whatever is under his knowledge, within his knowledge. His
That's
knowledge.
all.
So his knowledge was that somebody has killed my wife.
Okay.
Nothing else.
Anything?
I don't know anything else.
Anything?
I don't know anything else. Lordship, this is what, and then Lordship, so I will not go to
Because medical report is,
medical.
there is no doubt about it.
Yes, yes.
Because I don't think you have questioned. Only thing is sharp weapon, but that was not shown.
Yes, Lordship.
We'll come back.
Will, yes,
We'll
Lordship.
come.
PW 8, the SI, investigation officer. At page 23 years,
So no case for exception is set up.
nothing else.
Yes, PW.
PW 8, Lordship, page 23. On 26/11/2018, I was posted as second officer at Misamari police station. Some unknown person over telephone informed OC that Jagat Das was killed. Jagat Das killed his wife, followed by a quarrel. On the basis of the information, a GD entry dated so and so was made and endorsed me to inquire the matter. Accordingly, I visited the place of occurrence. On the arrival of place of occurrence, I found Jagat Das along with the dead body of the deceased Lata Boro in their room. The door of the room was bolted from inside. I knocked at the door. Accordingly, accused Jagat Das opened the door. I apprehended him. I found a dhow in the hand of the accused, which he used in committing the offense. I seized the dhow from the hand of the accused, right, Caesarly so and so. I informed circle officer about the incident, and as per his instruction, took the dead body to the police station as it was night. On the very day, that is on 26/11/2018, Niranjan Boro lodged an FIR regarding the incident. Accordingly, the OC registered the case, being Misamari case number so and so, and endorsed me to investigate the case. Exhibit 1 is the FIR. Exhibit 1-2 is the signature of the then OC Siam Singh Teran. On 27/11/2008, the circle officer conducted inquest on the dead body, and thereafter I sent the dead body for post-mortem examination. On 27/11/2018, I again went to the place of occurrence and prepared a sketch map of the PO. Exhibit 4 is the sketch map of the PO, and Exhibit 4-1 is my signature. I also recorded the statement of witnesses. I arrested the accused person and forwarded him to judicial custody. Thereafter, I collected the post-mortem report. After completion of investigation, submitted charge sheet against the accused 302 under 302 IPC. Exhibit 5 is the charge sheet. And this is my signature. M exhibit is the C is down. Cross-examination party, Lordship, next page. The place of occurrence is number 2, Dhanmora, which is about half kilometer away from the police station. In my diary, I have not mentioned how many persons gathered at the place of occurrence when I reached there. I do not remember how many persons gathered there. Village number 2, Dhanmora and Patidoi Bherela are falls under the jurisdiction of Misamari police station. I do not know the distance between the village number 2, Dhanmora and Patidoi Bherela. I do not know the distance between the village Ramnathpur and the place of occurrence. I recorded the statement of witnesses at the place of occurrence on 27/11/2018. Exhibit 4 is sketch map. I mentioned the case number as Misamari PS case number so and so. In the sketch map, I have not mentioned the door of the room was bolted from inside. I did not record statement of Satish Daimari and Khetriram Vasumotari, witnesses of inquest. All witnesses mentioned their village's name as Dhanmora. This may not be correct, Lordship, because some witnesses were from the other village also. The accused is also belongs to number 2 Dhanmora. On receipt of the FIR, the entry dated 26/11/2018 at 9:30 PM was entered. I do not know the scribe of the FIR. I do not record the statement of the scribe of the FIR, namely Shamanta Das. I did not inquire regarding the ownership of the mobile number by which the OC informed about the incident verbally. So he basically did not inquire anything, did not investigate. He didn't know anything, in fact. I did not inquire Niranjan Boro, from whom he came to know about the accused Jagat Das killed his murder. I did not sign the inquest report. I did not obtain the signature of accused Jagat Das in his statement recorded by me. I did not pray for recording confessional statement of the accused person. I recorded statement of 4 neighboring witnesses. It is not a fact that I investigated the case only on the basis of GD entry number so and so dated 26/11/2018. I did not submit copy of GD entry number so and so dated 26/11/2018 along with the charge sheet. I did not seize the wearing apparel of the deceased. I did not send the DAO to FSL. I shown the seizure list to learned CGM Sunitpur, Tezpur on 11/12/2018. I did not seal the seized DAO. I wrapped the DAO only with paper. It is not a fact that Jagat Das was not involved in any way in the offense. It is not a fact that informant Niranjan Boro killed the deceased. It is not a fact that all the witnesses are not the residents of village number 2 Dhanmora. They gave their address wrongly. It is not a fact that no incident occurred in village number 2 Dhanmora. It is not a fact the informant had land dispute with the deceased and hence he killed her. It is not a fact I falsely stated that accused opened the door of the room where the incident occurred. So investigation part, Lordship, I don't know. I mean,
These are, he did not seize the wearing apparel of the deceased.
correct.
One,
Yes.
did not send the seized out to FSL.
FSL.
And he showed the seizure list after delay.
Correct.
And he did not seal the seized DAO. These are the defects, apparent defects in the investigation.
These are
Whether that has dented the case of the prosecution.
the Lordship will decide.
Hmm?
Lordship will decide on that.
Oh, that is a
No, the Lordship would like to be honest, Lordship. Nothing, I mean, as far as that, no proper cross-examination has been done.
because
And no
it is not
different story
the,
was set up. No different
just
story.
because he was the only one from the community, the other villagers or neighboring villagers were inimically disposed towards him. That has not come out.
Only a
His
couple of-
quarrel was only with wife. Nothing has emerged
No
that
enmity has come out.
no
Your Lordship is
enmity
correct.
had the villagers had enmity,
Correct. Nothing.
and earlier he was harassed by villagers.
Or the
so possibility of-
son was harassing her, something like that. Nothing has come out.
Nothing has come. Nothing has
Yes.
come. Son was staying with his father,
Yes.
who was the first or second husband of the deceased. But nothing was there that disease, it was a possibility that they would,
The only thing, Lordship, what has come out in like DW's, this thing, DW one is there. There's,
who is PW9
PW number 9 is the person who has done the
inquest.
inquest of circle officer.
So
So nothing is there, Lordship. We need not go to that. Only this thing.
that is only executive magistrate. He has done formal thing.
Yes. So DW one, I'll just read
Ah.
out. Only one aspect has come out here. He has stated, I am the Gaon, he's Praveen coach, DW one. I am the Gaonbura number 1 and 2 Dhanmora village area. So he is the Gaonbura of that village, Dhanmora, where this incident occurred. I appeared in court today on the basis of summons. About 3 years back, Jagat Das was arrested by police and sent to jail. My residence is situated at a distance 3-4 kilometers from the house of Jagat Das. I have heard from public that Jagat Das tortured his wife. People did not question me during investigation. The informant is the son of second husband of the deceased Lata Boro. The husband of deceased was an employee of military engineering service and he has been receiving pension after his retirement from service. The husband of the deceased also possessed valuable landed property during his lifetime. After the death of her second husband, Lata Boro was married with accused Jagat Boro and used to reside in number 2 Dhanmora village. Patidoi Verela village is at a distance of 2 kilometers from number 2 Dhanmora village. After marriage of Lata Boro with Jagat Das, her son Niranjan Boro has been residing in a different village. Lata Boro reported me that her son Niranjan Boro quarrels with her off and on regarding landed property of her previous husband. This
Not
is-
Jagat Das, not Jagat
Not
Das.
the other husband, earlier husband. So like earlier husband was working in the military services. He has some landed property. So probably that landed property was inherited by his wife, Lata Boro. And this Niranjan Boro used to quarrel with her regarding the property. That is what, I mean, it has been stated by this DW. Other than this, Lordship, I could not find anything. I know Niranjan Mohilari of number 2 Dhanmara village. I do not know Nityananda Das of Ramnathpur village. Kagan Boro is a resident of Patidoi Verela village. Kamala Vasumutari is the Gaonbura of Patidoi Verela Gaon. The distance between the house of Kagan Boro and Kamala Vasumutari is about 2 kilometers as both are residents of 2 different villages. Witness Dipenchandra Boro is not a resident of number 2 Dhanmora village. Dandeswar Baglari, Leela Sorgiari, Niranjan Mohilari.
Hearsay. Hearsay.
Okay.
No.
Neighbors of Jagat Das. Upen Boro, Ajit Boro, Jointa Boro are neighbors, but their houses are situated at little distance. I have heard that there was a quarrel among Lata Boro, Niranjan Boro and Jagat Das on the date of incident.
Hearsay.
Yes. But this one is Lordship direct speech.
I have heard.
And
Only one thing Lata Boro reported to me. That is the first person account.
correct, Lordship.
But others are hearsay.
Lots of course. And one sentence in the cross-examination, Lordship, the last sentence. That I know Niranjan Boro quarrel with Lata Boro. So prosecution story may be only that much, Lordship, that maybe they have some quarrel, mother and son, about the properties of late father. And because of that, maybe some quarrel happened. I cannot say more than this, Lordship, because it's not on record. 313 statement, Lordship, only this paragraph 30, only that statement. that-
Question number 2.
Yes, Lordship, question number. No, when I came from work, I found the dead body of my wife inside the house.
Whether this can be termed as a plausible explanation
So whether Lordship,
under 313.
Lordship, if it is asked from the other side, whether this is sufficient in 313 or not.
The
Whether
question is,
whether 106 evidence act,
you have to see that circumstantial evidence.
correct.
Right?
So whether prosecution has
Few
really,
things I have said, these are the circumstances. Now, in a case of circumstantial evidence, prosecution can only prove those circumstances which is possible to be proved by the prosecution.
Absolutely.
And then if the, now that recent judgment says that if the prima facie case
Has been made out.
made out, then the honors will shift to the accused.
So now
Well,
like
no,
what-
it was not there, not a iota that you reached there and or you were inside the room only for 5 minutes or 1 hour, 5 hour, 10 hour. It will be difficult.
those were not
Nothing
there.
has been set up.
Those are not there. Those are not there. on the-
Nothing has been set up, and this kind of injuries is not a matter of 1 second.
Yes, yes, it will take some time.
8 chop wounds means
It takes some time.
some time,
Yes.
and exceeding this is unfair advantage. Exception 4 will not come in. Now there is nothing about grave and sudden provocation. To only thing is that in the absence of those, it is considered to be a culpable homicide
The only-
and amounting to murder. See the
only
nature of
the-
injuries.
So only doubt that arises is that whether, whether prosecution could made out a prima facie case on the face of it, because, there was no eyewitness. Now his explanation is that he has come there and like he found the dead body there.
The core of the prosecution story is not disturbed,
Yes.
appears to be. That is the core of the prosecution story.
Now whether the prosecution.
These are the
could leak
circumstances.
The whole factual thing.
You were inside.
Yeah, I was inside, that is true. Lordship, but
You were with the dead body. The dead body with having so much injuries. House was bolted from inside. You came out with a dao only after arrival of police. All those
because I'm
circumstances
scared. Lordship, yes.
And they-
It's not-
claim to have seen it, and their arrival is also appears to be explained properly. Their knowledge. That information went out from the house of Niranjan Mohilari,
Yes.
then sister of PW5, then PW1, then PW1 and PW5 reached together. They were the first one, and their heart of the testimony is not disturbed. And appears to be truthful.
Correct, Lordship, only thing.
Appears to be truthful.
Only thing is, Lordship, what could have been the motive? Now, motive is, motive is
But
not
there is
some
some that you used to enter into quarrels.
husband and wife, Lordship. be in their
Yes,
household, Lordship.
yes, but and on the date also there was a quarrel. So how to
But at the same
extricate
time-
out of the
at
situation?
the
There is
same
no
time-
explanation.
But at the same time, Lordship, a responsible person like a Gaubura has told that there are incidences of quarrel between the son and mother. As far
That's
as property is
reported.
concerned.
It's a case of murder, not a case of simple assault.
So Lordship, that, I don't think, Lordship, I will go to other.
No hypothesis will
That-
come. 106 will come.
So Lordship, as far as 106, Lordship has already pointed out that 106, there is a case law recently decided by the Supreme Court.
Anis
This
or
is,
Baldev.
this is Bulgaria. So 106 is properly explained. I was mentioned.
You got another? Okay, give us
I already given Wazir Khan.
Wazir Khan, Shah or Khan?
Khan.
Khan, yes.
So,
Justice Padiwala or
Yes.
Pardiwala.
all clear by Padiwala.
Pardiwala and
Justice.
Professor Kumar. So he has explained so I'll just read out one particular paragraph from that, Lordship. As far as prosecution from prosecution bringing in prima facie case. Lordship, one paragraph, I'll not disturb, take Lordship much time.
বলবীটো গৈছিল ন?
So paragraph, I will not trouble your Lordship with other aspects of the matter, only paragraph 36, Lordship. The Sambhunath's case, what is-
Shambhunath.
Yes, that is one of the very first cases when Justice Vivian Bose has written this. So para 36, Lordship, at
Hmm.
page 13. So he talks about 106, Lordship is already aware of this. I'm just 36. May I read out, Lordship? The
Hmm.
small paragraph. The aforesaid decision of Sambhunath has been referred to and relied upon in Nagendra Shah versus State of Bihar, wherein this court observed as under. Thus, 106 of Evidence Act will apply to those cases where prosecution has succeeded in establishing the facts from which a reasonable inference can be drawn regarding the existence of certain other facts which are within the special knowledge of the accused. When the accused fails to offer proper explanation about the existence of the said other facts, the court can always draw an appropriate inference. When a case is resting on circumstantial evidence, if the accused fails to offer a reasonable explanation in discharge of burden placed on him by virtue of 106 of the Evidence Act, such failure may provide an additional link to the chain of circumstances. In case governed by circumstantial evidence, if the chain of circumstances which is required to be established by the prosecution is not established, the failure of the accused to discharge the burden under 106 Evidence Act is not relevant at all. When the chain is not complete, falsity of defense is no ground to convict the accused. So these are subtle principles, Lordship. I need not bother your Lordship with all this. Only thing is that my humble sum is that 106, Lordship, if he says that
106 will not come into picture at first.
no, 106
It will come into picture only after the prosecution has been able to set up a prima facie case.
correct, Lordship. So now prosecution story is that everything points out to the accused that he has committed the murder.
Hmm.
But his explanation is that when he came to the house, he found the dead body there.
But that has to be in a parameter of preponderance of probabilities. That whether that meets the criteria of preponderance of probabilities. That DW1, he is not saying anything about that. Thus, you set up in 313. 313 comes before defense evidence. So you did not set up that also.
Only thing he stated that, I came there and I found the dead body.
No. That is not a very reasonable explanation and plausible.
Lordship, under his knowledge, if something is there, if he would have known that, fine, this has been done by somebody else, then he would have stated it. Because which is not within my knowledge, I can't say.
Had you raised even after, suppose, after committing the crime also, if you came out of the house and raised halla, that would have been also a situation to be considered. But here it is not the case. Vaulting the house.
But Lordship, can it not happen that a person is so panicked and scared that
These are all imagination.
These are all, Lordship, human
These are not.
characters. Every person behaves differently, Lordship. Every person
This
behaves
is
differently.
too far-fetched. Is Arota কি নাম আছে? নহয় আনিছৰ নহয় নহয় সেইদিনাখন যে মই ইউজ কৰিছিলো
There are many bus judgments they have.
no one more দেৱকী নন্দনটো ক'ত গ'ল দেৱকী নন্দন হা
Because I found it hard to really escape, so I am not referring to many of the things under 106.
yes, sir.
But this case.
This
case
paragraph-
report is really explained
paragraph
106.
54
Paragraph 54, no, see?
দেৱকী নন্দন মিশ্র
Yes, 54, yes. Yes, Lord, sir. Plausible explanation.
that quote
Yes.
quoted part
May I read out, Lord? Sir?
yes
It is true that in a case of circumstantial evidence, not only should the various links in the chain of evidence be clearly established, but completed chain must be such as to rule out reasonable likelihood of innocence of the accused.
then
But in a case where various links have been satisfactorily made out and the circumstances point to the accused as the probable assailant with reasonable definiteness and in proximity of the disease as regards time and situation, and he offers no explanation which, if accepted, though not proof, would afford a reasonable basis for a conclusion on the entire case consistent with his innocence. Such absence of explanation or false explanation would itself be an additional link with to complete the chain.
so appears proximity of time and situation it appears to you are a probable assailant now it was your onus to provide explanation not mere statement explanation means something more than statement
Yes.
that was not there
There is not there. That is.
yes ms bhuyan
Lordship, 1 second, Lordship. I'll just place one more case on motive. Lordship, kindly have a look into this. I will not read out. This is, Lordship, a recent case also. Sanjay Krishan called Manoj Mishra and Arvind Kumar. They have decided. State of Madhya Pradesh versus Fulson Rathur. As far as a motive is concerned.
it is required in a it should be in a case of circumstantial evidence
I'll just place
but
it,
if
Lordship.
motive is not established because it is something which is in the mind
Minds.
so it is science has not improved to exact everything
Yeah.
but what is there what is does it say
It says about a motive should be.
it should be the effort of the prosecution to
Yeah.
at least
Paragraph 24(1), Lordship. That's the
Paragraph
only
24.
paragraph I'm relying on.
paragraph 24 24 yes
We shall now examine as to what were the circumstances relied on by the prosecution and as to how they were sought to be proved. Additionally, we shall examine as how the High Court dealt with the evidence on those circumstances with a view to find out whether there is any perversity in its view, reasoning, warranting, and inference. In the instant case, the prosecution relied on the following circumstances: motive, A, motive, B, disclosure statement and recovery, extrajudicial confession, and accused taking the disease with him, and soon thereafter the disease was found in an injured state. We shall examine each of these circumstances separately. Herein below, the motive. 1. According to the prosecution, the appellant and the deceased used to quarrel because the deceased had kept her jewelry with her sister. However, the above reason for quarrel was not found proved because the prosecution evidence revealed that the jewelry had already been returned back much before the date of incident. Therefore, to prove motive during trial, prosecution developed another story, which is that the appellant desired his wife to claim a share in her ancestral property, which resulted in quarrels. This motive neither appealed to the High Court nor to us because firstly, it was an improvement in the prosecution story. Secondly, not much evidence was laid to substantiate the same. And thirdly, if the wife is killed, how could her husband derive interest in the property? Thus, in our view, the prosecution failed to prove the motive set out by it. No doubt, absence of
This
motive.
part is important,
Yes, yes.
no doubt.
No doubt, absence of motive by itself may not be sufficient to dislodge the prosecution case if other proven circumstances could form a chain so complete as to indicate that in all human probability, it is the accused and no one else would commit who committed the crime. But in a case based on circumstantial evidence, motive plays an important part. Because not only it makes the story believable, but also helps the court in fortifying an inference which may be drawn against the accused from the other attending circumstances. So motive was in this case, Lordship, in this particular case, seems to be missing. Though some statements have come, but DW one again, he has come up with a different storytelling. So Lordship, may kindly look into this matter. I concur.
Yes, madam.
I concur.
The prosecution could prove, your lordship, the presence of the accused person who was inside the room, my lord, and door was locked when the police arrived, your lordship, as well as when neighbors as well as PW1 arrived at the place of occurrence. He was found inside the room, my lord. And lordship, from the evidence of the IO, lordship, he deposed the door was bolted from inside and there was a weapon of offense in the hand of the accused person. Lordship, so under 106.
His
and
testimony is also consistent with
Okay.
the other.
My lord, little bit of inconsistencies here and there, lordship, but the defense tried to present another case, your lordship, page 18. But they could not prove it. Cross-examination of the defense of PW6. Last 4 lines. Susan Borough, your lordship has found it? Susan Borough was the first husband of the deceased. He is still alive and resides in our village. I do not know when Lata Borough entered into marriage with the accused. Niranjan Borough was the son of Lata Borough through her first husband, Susan Borough. When Niranjan Borough informed me about the incident, I was at home. He rang me from the house of the accused. Then, your lordship, last.
We don't know how many husbands the disease has because somebody says 2, somebody says 3.
Lordship,
There is one
fine.
Paniram also.
Yes. It is not a fact that Susan Borough committed the murder of the deceased and to save him, I deposed falsely. Then thereafter, it is not a fact that Niranjan Borough committed the murder of his mother for entering into marriage with the accused. It is irrelevant as Niranjan Borough is my friend and from my village, I deposed falsely. They tried to present another case, another story, but they could not prove it.
Which one? True
It-
PW6
yes, page 19.
committed the
It's
murder.
not a fact that Susan Borough committed the murder of the deceased, Susan Borough, first husband, and to save him, I deposed falsely. It is not a fact that Niranjan Borough committed the murder of his mother for entering into the marriage with the
One,
accused.
because it appears one more was there, Paniram. He died, I think.
Yes.
I think that tussle that the defense tried to project was that Paniram left behind property.
Properties.
And there was dispute between PW1 and his mother over that property. And Susan Borough was husband of this informant. He is alive.
My lord, he is alive.
He's alive. So these used to receive pension from Paniram,
Paniram.
perhaps.
But they could not prove it further. Demolished the prosecution case. But even if there are inconsistencies, the lordship, one fact remains, lordship, he was there inside the room, no explanation from his side. So it goes like everything.
With Dow,
Yes.
with dead body.
Yes, my lord. And your lordship,
With
even
so
if there
many-
is quarrel,
With so many 9, 10 wounds, chop wounds.
even if that is a result of the quarrel, the lordship may not give that the benefit of.
With the
yes.
case set up,
Yes, no.
say exception 4 will not come,
Come.
exception 1 is not set up.
Lordship.
That
So,
is the,
it's complete, even if there is no motive
that
set out by the defense.
there lies the problem in defense.
My lord.
Everybody in every case. APS, that everybody goes for acquittal in every case.
I know.
That instead of acquittal, a case could have been set up
Confirm.
either under
Absolutely, Lordship.
Lordship.
part one or part two. But that is there lies the problem of the defense. The
Maybe.
client
But
goes to the counsel.
late Jatin Chowdhury is not there.
Let client goes to the counsel and says that yeah, you will be acquitted. I'll make you release. So they don't set up the case for part one or part two, 304. And there lies the problem.
Yes.
Instead of life, things could have been 5 years, 10
Even if
years,
10
7
years,
years,
right.
6 years, 8 years. No, that is the problem. Now you cannot improve the case in appeal.
That's- I understand.
I'll be relying on Lordship Wajir Khan versus State of Uttarakhand. 106.
This one,
Yes.
Wazir Khan. Oh, this is Madhya Pradesh,
military.
Ulsan Rathore.
INSC 67.
Bushra.
06.
Husband killing wife.
Yes.
Record is that his wife was killed by robbers. 313.
Lordship.
Wazir Khan says, on the date of the incident, his wife was killed by robbers.
In this case, first he was acquitted. State preferred appeal. Lordship.
Okay.
Against that, he came, it was done, he was convicted again, then against that, he went to the Supreme Court.
What Supreme Court says?
Lordship,
A reversal of acquittal.
no, your Lordship. It was confirmed, my lord.
Huh? Okay, High Court reversed the acquittal,
Yes.
or what?
Yes, High Court reversed the order of acquittal, then he went up to the Honorable Supreme Court. Supreme Court says, Lordship, Honorable Supreme Court uphold the High Court judgment. Provision of 106 has been explained. Mikaram case has been discussed. Ganesh Lal. The maybe and must be factor has been discussed. Right?
If something has happened inside the house, it will be extremely difficult for a prosecution to lead evidence to establish the guilt of the accused. If the strict principle of circumstantial evidence is insisted by the courts. The law does not enjoin a duty on the prosecution to lead evidence of such character which is almost impossible to be laid, or at any rate extremely difficult to be laid. In such situation, there are defects in the investigation, but what are the other evidence which could have been laid?
That is why,
Nothing.
Lordship. In this case, I mean, I like with due respect, Lordship, I mean, it was not properly done.
Heard Mr. Ekorita, Lanet. amicus curiae for the appellant and MSP Priya. Learned additional senior counsel and additional public prosecutor assisted by M. Chakraborty. Learned counsel for the respondent state. First of arguments are heard. Judgment is reserved.
Obliged.
1989. And at the relevant time,
DPS continue.
notification 1 of 89 was in force. Lordship had
Notification
1 of 89.
1 of 89. Yes.
Following that, sample was drawn. And Lordship, I have gone through the latest judgment also, but this aspect of the matter was probably not argued or it was not taken into consideration.
A bit louder.
Lordship, I've gone through the latest judgment also, where 52 has been interpreted. But Lordship, this argument was probably not made or this was not considered by the Honorable Supreme Court.
Which one?
Regarding Lordship, validity of notification on of 89. And Lordship, I placed the latest rule of 2022. It says, again, I'm with the court of repetition. That it's rule 29 of the 22 rules.
Rule 20.
It is available on the record also. Narcotic drug and
A
substantive
plastic
substance.
apparent also.
State storage sampling, rule 2000.
1 minute, 1 minute.
2022.
Why 22 will be
Lordship,
necessary in this case?
no, Lordship, because Supreme Court in case of Mohanlal, that directed the government to come with a specific notification. And section 52A starts with the word that 52A. Lordship may come to section 52. The heading of the section is disposal of.
Oh, 1 minute, so we don't have the NDPS.
This aspect of the matter was not considered. Supreme Court simply is that when there is an 52 is there, sample was not drawn following section 52.
52A.
A Lordship. No.
52A.
52A.
Yes, 52A.
Disposal of seized narcotic drugs and narcotic substance. 1. The central government may, having regard to the hazard's nature, vulnerability to theft, substitution, then constraint of proper storage or any other relevant
2022.
consideration. In respect of any narcotic drugs also or conveyance by notification in official gazette, specify such narcotics drugs and controlled substance or conveyance or class of narcotic drug or class of substitute substance or controlled substance which shall be soon may be after their seizure of disposal so and so. So this section says that government should come with a specific notification. At the relevant time, different notifications were there. Now in 2022, as mandated by the Mohanlal case and in conformity with the section 52A, this rules was
No, let us see 89 first.
Lordship.
Let us see 89.
Yes, that is available on the record.
That is read standing order 1 of 89.
Yes, but it is page probably 3. Standing order 1 of 89. Whereas the central government consider if necessary and expedient to determine the manner in which narcotic drugs and psychotic substance as specified in notification 4 of 89 dated 29th May 1989. And so and so.
In exercise of the powers conferred by
consider section
Subsection one of
52A.
the A. So this is obviously published in
Yes, officer. There is no.
so sampling is 2.1 and 2.2
Yes, boss.
and
2.1.
also
4 Lottery.
4.0.
With regard to that is pre-trial disposal. That provision is there.
4.0. Yes, we'll come to
Yes.
that. We'll come to that.
Then Lordship may come to.
Now read subsection.
Lordship.
Subsection 2.
2, yes, Lordship. Here any narcotics, drugs or substitute substance, controlled substance or conveyance has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory of such narcotic substance and so containing such detail relating to their description, quality, quantity, mode of taking, marks, number, and or such other identifying particulars of the narcotics so and so or packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider the relevant to identify the narcotics so and so in any proceeding under this act and make an application to the magistrate, then 1 A, B, C and D provisions are there.
Now let us read 1 and 2 together.
Yes, sir.
Subsection 1 says regarding disposal.
Regarding the hazard nature of the vanity.
Regarding disposal.
Proper storage space.
Now, if you read subsection 2,
Not see.
where any narcotic drugs has been seized, it is not speaking about disposal
Yes, sir. Yes, sir.
and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. So after seizure, it is to be sent to the officer in charge or to the empowered officer. Then the next duty for the officer in charge or the empowered officer is to prepare an inventory,
Inventory.
giving descriptions
Yes, sir.
and nearest to any magistrate,
Yes, sir.
Then for the purpose of three purpose,
Yes, sir.
A, B, C.
Yes, sir.
And subsection 3 says, where an application is made,
Under subsection 2, the magistrate
shall allow.
Yes.
So this subsection 2 and 3 is not saying anything about disposal.
One says. about
One thing is seized contraband.
Make samples. How to make.
After seizure, central government, as per subsection 1, shall provide procedure for disposal.
Disposal and as well as sampling also.
No, sampling, where is that?
If
Where is that?
where we read together, then probably.
No, where is that? Don't read something into subsection 1 which is not there. Sampling comes in subsection 2. Now let us read once again Mongilal.
Probably Mohanlal.
Huh?
Mohanlal.
Read from paragraph 12.
Mongilal or Mohanlal.
Mohanlal. Then we'll read Mongilal.
Yes, sir.
Paragraph 12. Paragraph 12,
Holding the citation.
the subheading seizure and sampling.
Yes, seizure and sampling. It is in paragraph. Section 52A(1)(a) of the NDPS Act empowers the central government to prescribe by notification the procedure to be followed
To be followed for,
for seizure, storage and disposal.
where is that sampling?
What's it?
Where is the sampling?
No, here in this case, that is, that. has
So
been
subsection 1 says about seizure,
seizure,
storage and
of-
disposal.
Yes.
Hmm.
The central
Read.
government have been
The
exercising that power, issued standing order 1 of 89, which prescribes the procedure to be followed
While conducting
seizure
seizure.
of the contraband.
Hmm.
Two subsequent standing orders dated 10/5/2007 and other dated 16/2015 dealt with disposal and destruction of the contraband and do not alter or add to the earlier standing order that prescribe procedure for conducting seizure.
Hmm.
Paragraph 2.2 of the standing order 1 of 89 state
Hmm.
that the sample must be taken from the seized contraband on the spot at the time of recovery itself.
Hmm.
It reads 2.2. All the packages containers shall be serially numbered and kept in lots for sampling. Sample from the narcotic, drugs and psychotic substance seized shall be drawn on the spot of recovery in duplicate in presence of such witnesses, panchas, and persons from whose position the drug is recovered, and mention to this effect should invariably be made in panchanamas drawn on the spot.
Hmm.
Then, most of the state, however, claim that no samples are drawn at the time of seizure. Director of Revenue Intelligence it by or they only agrees, which claims that the samples are drawn at the time of seizure, and Narcotic Control Bureau asserts that it does not do so. That is thus no uniform practice or procedure being followed by the state or the central agencies in the matter drawing of the samples. This is therefore an area that needs to be suitably addressed in the light of the statutory provision, which ought to be strictly observed in given seriousness of the offences under the Act and the punishment prescribed by law in the case are proved. We propose to deal with issue no matter briefly in attempt to remove the confusion that prevailing regarding true position as regard doing of the samples.
That prevails.
Yes, sir.
That prevails. Yes.
Basically, this is my submission, Lords.
That prevails. That prevails means of it is existing
Yes, existing.
regarding the true position of as regards drawing of samples.
Drawing of
True position.
Yes, Lords.
52 quoted.
52 quoted.
Then paragraph next.
Next paragraph, they come to paragraph. It manifest. 15.
Manifest means it is already 52A when it is incorporated. Yes.
Lordship may skip.
No, we'll not skip.
Okay,
Paragraph 15 will not skip.
I'm ready. It is manifest from section 52A to C supra that upon seizure of the contraband, the sample has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under section 53, who shall prepare an inventory as stipulated in the said provision and make an application to the magistrate for purpose of A, certifying the correctness of inventory, B, certifying the photograph of such drugs or substance taken before the magistrate as true, C, to draw representative samples in presence of the magistrate and certifying the correctness of the list of samples so drawn. Subsection 3 of section 52A requires that the magistrate shall as soon as may be allowed the application.
Now
This-
this implies.
This
Yes.
implies that no sooner the seizure is effected, the contraband forwarded to the officer in charge of the police station or the officer empowered. The officer concerned is in law duty bound to approach the magistrate for the purpose mentioned above, including the grant of permission to draw representative samples in his presence. Which samples will then be enlisted and the correctness of the list of samples are drawn certificate by the magistrate. In other words, the process of drawing samples has to be in the presence of under the supervision of magistrate and the entire exercise has to be certified by him to be correct. The question of drawing samples at the time of seizure, which often than not takes place in absence of the magistrate, does not in the above scheme or thing arise. This is so especially when, according to section 52A of the Act, samples drawn and certified to the magistrate in compliance of subsection 2 and 3 of section 52A above constitute primary evidence for the purpose of the trial. Now, Lordship, suffice
Hmm. Hmm. Suffice.
suffice is to say that there is no provision in the Act that mandates of taking sample at the time of seizure. This perhaps why none of the state claims to be taking sample at the time of seizure. Be as it may, a conflict between the statutory provision governing of taking samples and the standing orders issued by the central government is evident when the two are placed in juxtaposition. There is no gainsay that such a conflict shall have to be resolved in favor of the statute on first principle of interpretation, but the continuance of the state notification in its present form is bound to create confusion in the mind of the authorities concerned instead of helping them in discharge of their duty. Now, Lordship, the central government would therefore do well to re-examine the matter and take suitable steps in above direction.
That is an advice to withdraw. You better withdraw, otherwise everything will
No.
prevail.
No, Lordship, what happened thereafter? Lordship, interestingly, that notification was not interfered.
Notification?
The notification of the standing order was not interfered by the Honorable Supreme Court.
Not required.
No.
What will prevail has been already categorically and emphatically held.
And Lordship,
That purpose of sampling, that procedure of sampling is not authorized by law.
yes, this is correct, Lordship. There is no quarrel
Then-
about that. My submission is that since before Mohanlal, two procedures were there. One as per act and other by the that standing order. And that was all along followed by maximum all the agencies. Lordship.
No, not except director of, that is a statement on oath before a court.
Lordship,
Don't,
no, no,
paragraph 13.
yes, Lordship.
Except Directorate of Revenue Intelligence, Customs also said,
They are not following.
not following. Then why you are following?
Then Lordship, because there is some flaw in the. Lordship may come to.
How do you interpret these paragraphs?
No, Lordship,
This central government would, because that is not perhaps under challenge, so it is not, cannot be set aside. But court has clearly interpreted which one will prevail.
yes, that.
The sampling procedure laid down in 52A will prevail.
Yes, Lordship, there is no quarrel about that. Let's see, but let's see, last paragraph, please judgment. Paragraph 31. 31(1). Sum up with direct is under. (31.1). No sooner the seizure and of narcotic drug and psychotic substance and controlled substance and 31.1. To sum up. Last page, Lordship.
Before that, you read 30.
Lordship. In order to avoid any confusion arising out of continued presence of two notifications on the same subject, we make it clear that the disposal
This
of
is regarding disposal.
the correct
okay.
disposal.
Okay,
We come to paragraph 31. Lordship.
31. Okay.
We are concerned with 31.1 is applicable in our case. To sum up, we direct is under. Active point one. No sooner the seizure of narcotic drugs and psychotic substance, controlled substance and conveyances is effected, the same shall be forwarded to the magistrate in charge of the nearest police station or to the officer empowered under section 53 of the Act. Then officer action shall then approach the magistrate with application under section 52A of the Act, which shall be allowed by the magistrate as soon as may be required under subsection 3 of section 52A, as discussed by us in the body of this judgment under the heading seizure and sample. The sample shall be done under the supervision of magistrate as discussed in paragraph 15 to 19 of this Act, of this order. What is the opening word of this paragraph? No sooner the seizure, that means from
At the earliest.
earliest. So we can interpret that from the date of pronouncement of judgment. If anything is contrary to section 52, then entire exercise will go.
Nowhere says,
No,
which is not there cannot be interpreted in a manner. Nowhere it says, no sooner means as soon as, that is interpretation of subsection 3.
Except the judgment was pronounced in 28/1/2016. This is my submission.
Okay, okay,
And regarding 52A.
okay, 1 minute, your submission.
This is my second submission. That's it, rule 2022. Rule 2029,
Rule
rule 2022,
2022.
rule 29.
1 minute. Rule 2022.
That is there, Lord, figure that out.
Yes.
So it may come to rule 29. also.
Yes.
The rule 29 speaks about repeal and savings. The standing order 1 of 88, dated 15th March 1988, standing order number 2 of 88, dated 11th April 88, issued by the Narcotic Control Bureau, standing order 1 of 89, dated 13th June 1989, issued by the Government of India, Ministry of Finance, Department of Revenue. The notification of the Government of India, Ministry of Finance, published in Gazette of India, Extraordinary Part 2, in section 3, subsection 1, height number so and notification of Government of India dated so are hereby repealed. Then 2. Notwithstanding such repeal, anything done or any action taken or purported to have been taken or done or taken under any of the standing order or notification repealed by sub-rule 1 shall, insofar as it is not inconsistent with the provision of this rule, be deemed to have been done or taken under corresponding provision of these rules.
Yes.
Any action taken under notification 1 of 89 has been saved by this.
Has it saved that not inconsistent with the provisions of statutory prescription contained in 52A?
That what is not there, what is said.
How can a notification repeal a statutory provision?
No, that cannot be.
So 52A is there.
No, that cannot, that is there, Lordship, my submission, because seizure was prior to Mohanlal case. And the Lordship in none of the judgment, this notification has been interfered with. In Mohanlal Lordship subsequent issue for two
In a
judgment.
criminal appeal or trial, statutory provision or rules cannot be set aside.
Lordship, yes, correct.
Criminal appeal, we cannot set aside. Or in a trial. It
Yes,
is,
yes, Lordship.
it is the interpretation of a statutory provision or rule, whatever, a practice procedure laid down in statute and rules. Those are followed or not followed.
No,
That
no,
is to be seen in a trial. It is under 226 or Article
Yes.
32.
Yes,
This can be set aside.
yes.
Lordship, in case of Mohanlal,
We have to
that
challenge.
was, that is to be seen, whether
Inconsistent with the rules.
It is inconsistent.
that
It is not said.
52A is law, parliamentary
Yes,
law.
yes. 89 it was brought into. What's it, problem in this case was there, because there was a confusion, that's why Lordship Mohanlal, Supreme Court think it proper to discuss all these things. And Lordship in recent judgment, two judgments where Supreme Court says that if 52 is not followed, then it will be the vessel report will be nothing a piece of paper.
Hmm?
Nothing will be, it will be a piece of paper, it cannot be relied.
Hmm.
That
Which one? Waste paper?
Mohammed Khalid,
Mohammed Khalid,
Mohammed
there are two judgments, Yusuf and
Mohammed Khalid.
Mohammed Khalid.
আৰু এইটো বকি
Yes,
মাৰি-
Lordship.
Mohammed Khalid is specific lordship.
Master আছে, clip মাৰা আছিল যে।
24.
Clip মাৰা আছিল যে এটা। এটা clip মাৰি থৈছিল ন?
2024, 5 SCC 398.
One minute. Rule aggregation, Mohammed Khalid.
Paragraph number 26.
SCC provided. Mohammed
Khalid.
Khalid.
In paragraph number 26.
Khalid. Khalid to 9. Oh. Good. Hmm. Which paragraph?
26.
Paragraph 22, admittedly,
26 of specific distance, rest of the part.
20.
22 probably. It start from word
Yeah,
admit-
19, it start from 19 lordship. 19, 20, 22, then 26. One is the-
No,
admittedly no proceeding under
ICC.
section 52A of NDPS Act were undertaken by the investigating officer.
1 minute, I am not getting from microplay. Yeah, Mohammed Khalid. Yes. Yes.
Start from the word admittedly.
Paragraph
22.
22. Admittedly,
Admittedly,
SCC.
we was in the last page.
Oh, 26.
Admittedly,
Yes.
26.
Admittedly, no proceeding under section 52A of NDPS Act were undertaken by the investigating officer PW5 for preparing an inventory and obtaining samples in presence of the judicial magistrate. In view of the same, the FSL report is nothing but a waste paper and cannot be read in evidence. The accused number A3, A4 were not arrested at the spot. The offenses under section 20B to C, there will be the procedures, manufacture, process, sale, purchase, transport, import, and export of the cannabis. It is not the case of the prostitution that the accused number A3 and A4 were found in possession of the ganja. The highest case of the prostitution is true, is not substantiated by any admissible or tangible evidence, is that the two accused had conspired sale and purchase of ganja with accused number A and two. The entire case of prosecution against these two accused is based on integration of note of accused number A and two. It is fertile that the confession of accused recorded by the police officer is not admissible in evidence as the sample hit by section 25 of the Act, of the Evidence Act. Neither the trial nor the High Court averted to this fatal flaw in the prosecution case and proceeded to convict A, 3 and 4 in a sheer mechanical manner without there being any iota of evidence on record of the case so as to hold them guilty. As consequence of the above discussion, we are of the firm opinion that the prosecution has miserably failed to prove charges against the accused. The evidence of the police witness is full of contradiction and it is thoroughly unconvincing. The conviction of the accused appellants as regards that the trial court and affirmed by the High Court is illegal on the face of the record and suffers from highest degree of perversity. Recently, the judgment dated so and so passed by the High Court, affirming the judgment in trial court, convicting and sentencing the accused appellant for charge under section 8C, read with 20D2C of the NTPS Act is hereby quashed and set aside. The appellant are acquitted of the charges. They are in custody. Lordship, probably the main accused were not party in the.
No, I have seen A1 and A2, they were arrested on the spot.
Yeah, they were in or.
Paragraph 5.
The appeal was filed by A3 and A4.
A2, A3, everybody,
No,
but A2 expired. So proceeding stood abated against him before the High Court.
Yes.
Then A2, A3, A4 preferred appeal. Those were affirmed perhaps by the High
High
Court.
Court.
Yes, sir. Then on part of
Then
A3 and A4, they preferred.
let us see about A2. What happened to A2?
A3 is Mohammed Khalid.
No, no, A2.
Oh, A2. Safiullah.
A2 is one
Lordship,
Safiullah.
Yes.
A3 and A4 have preferred criminal appeal number so and so. And A2 has preferred criminal appeal number 1611 for assailing the impugned judgment dated so and so of the High Court, whereby the conviction recorded and sentence awarded to the accused by the trial court have been affirmed.
Hmm.
But he preferred appeal number 1611.
1611. Yes.
This is 1610 by A3 and A4. Then in one paragraph, but the paragraph probably 12. The learned counsel representing A accused number A3 and A4 urged that these accused were not found present at the spot at the time of seizure. They were arrested on 30th of May 2009, merely on the basis of integration. No.
Appeals are allowed. Appeals last
Yes,
line.
last line.
Appeals are allowed.
Allowed.
2 appeals were decided. 1611 was preferred by A2
Hmm.
and 1610 was preferred by
It is A3.
A3 and A4.
Yes.
And now last paragraph, the appeals are allowed.
Both the appeals.
In
Both.
top- In top lordship, in the first title.
You are holding SCC.
No, lordship.
Ah.
This is.
Then criminal appeals number 1610 of 2023 and with number 1611 2023. Arising from judgment and order Muhammad Ishaq Ansari versus so and so. right?
Here it is.
And paragraph 20, sorry, paragraph not 20, paragraph 11. A3 and A4 have preferred criminal appeal number 1610 of 2023
Yes,
and A2 has preferred criminal appeal number 1611 2023.
yes,
Yes,
And both common judgment for this is the common judgment. Last paragraph, the appeals are accordingly allowed.
appeals are recording there.
Includes A2,
it is off.
includes A2.
It is in my copy, it is not there. Yes, sir.
We can have the original one.
No, Lordship, I'm not disputing.
So A2 was also
Yes,
Supreme,
then Muhammad Khalid, then
yes.
then
one
Yusuf-
more
Yusuf.
Yusuf.
Yusuf is also,
Let us see the date.
here.
Let us see the date here.
Here it,
13,
28/3/2020.
Credible information on 8/5/2009.
Yes,
It is before Mohan.
Mohanlal.
Yes.
No, that is what we are
I've also
looking
marked-
at
I've also marked that. It is of 2009. but
2009.
Yusuf is of 2020.
Let us see Yusuf.
no. It's
Uh,
NCB crime number 113 slash 2000 lots. registered.
2000.
Yes,
2000, after Mohanlal.
So how can you say that Mohanlal is prospective?
No, Lordship, my submission. Because in
That line,
yes,
well advised.
Yes.
Yeah.
that is, this is my submission. Lordship, as I submitted earlier, in none of the judgment, Lordship Honorable Supreme Court has discussed about non-applicability of notification, 1 of 89. Rather, in
Mohanlal is clear. I don't think it is more interpretation is required. Mohanlal.
no, Lordship, I'm not interpreting anything, but my submission is that because Supreme Court has clearly says that no sooner, that means from the and Lordship.
No, because of the confusion created by the notification, Supreme Court has once again said, you do it in this manner.
No, that is there is no confusion from 28/6/2016. There is no leniency that we have to follow section 52A. But-
And this creates the doubt. This has removed the doubt. Muhammad Khalid,
yes.
Mongilal,
Mongol
and Yusuf.
Simarjit.
Simranjit Singh,
No, I've gone through.
Bothilal,
I've gone through all
Bothilal
the-
Bothilal.
Yes,
At least 5 have
Yes,
clarified.
yes, Lordship.
We looked into it, the date of seizure, date of sampling, and all says 52A is in statute book
No,
since
that-
1980.
I'm not submitting, and Lordship, recently on 27/1/2023, our High Court, although appeal was, they were acquitted, but one objection was made. It is no more res integra that the case of the offence under NDPS Act, which provides stringent punishment, the authorities are expected to follow the statutory procedure strictly. Now,
No,
in this case, at hand, the standing order 1 of 89 was not complied with, nor the provision of section 52 of the act has been complied with. So Lordship, every time the notification of 1 of 89 was given, was not given that it will not be applicable or it is and the recent 22 Lordship saving clause says that even if there is a appeal. And another thing, Lordship, the word my state was never defined. There was a confusion with respect to regarding my state, whether it will be executive magistrate or judicial magistrate. But the notification 22 has been clarified. The word magistrate has been defined that it must mean like judicial magistrate.
Central government is under confusion. What kind of
No, Lordship, there was a different type of judgments regarding what the definition of my state. In somewhere, in some high court says that the samples can be done in presence of executive magistrate. But probably that has been clarified in 22. Section two D,
Two D.
two D. Magistrate
D.
means the judicial magistrate.
Two D. Two D কত আছে হ্যাঁ? Two D. Two D.
Two D laws,
B.
D.
Notification.
That rules.
Rules laws. Complete.
Rules. Two. Section two.
D.
No, that is rule.
Yes, rule.
Section 229. Roman 29. Words and expressions used herein and not defined, but defined in the Code of Criminal Procedure have the meanings respectively assigned to them in that code.
Yes, Lord.
CRPC.
Section 51 also, Lordship.
Section 3. Construction of reference. In this code, any reference without any qualifying words to a magistrate shall be construed unless the context otherwise requires in relation to an area outside the metropolitan area as a reference to a judicial magistrate in relation to a metropolitan area as a reference to a metropolitan magistrate. This 22 is an old, is a something old wine in a new bottle. This
Yes.
22 magistrate means judicial magistrate. NDPS says whatever is not defined
That we,
we should refer to CRPC. And CRPC says which is existing since 1963, any reference to a magistrate is judicial magistrate or metropolitan magistrate. What else is required?
no, Lordship,
Confusion is created by the authorities themselves.
Lordship, there are some judgments which,
Which judgment goes in the
No, no,
Supreme Court has not said.
no, Supreme Court has.
We are not
it-
bound by those judgments.
It has not. got
We
to
can only go by Supreme Court and
Yes, Lordship.
CRBC and
Yes, sir.
NDPS.
No, there is no confusion about that.
NDPS says whatever is not defined, you
Yes.
please refer to CRPC. And CRPC section 3 says
Yes.
magistrate
That-
without any qualifying words
That-
means judicial magistrate or metropolitan
that-
magistrate.
that ex-
Metropolitan magistrate is also a judicial magistrate. Yes.
That exercise was not undertaken by anybody, Lordship.
Huh?
That exercise was not undertaken.
No, nobody reads the book.
That is the problem, Lordship.
Then what to do? What to do?
This is the difficulty nowadays.
Magistrate means magistrate. This 22 what? That is an old wine in a new bottle.
Yes, yes,
Nothing else.
you can say that.
Nothing new.
That is the problem, Lordship. Nobody is pondering all this. thing.
I know. You can see
So
clearly.
this is my humble submission, Lordship,
Okay.
because I cannot submit contrary to the law. I can make my submission. And Lordship,
It is not possible to dictate. We have to.
Lordship, one thing, in the paper book,
Yes, please.
exhibit, Lordship may come to page
Hmm.
58.
No, talk.
Page 58. Let's say one thing is there, section 52 was amended in 1989. That was in the statute book. But my submission is that while seizing, the notification was taken into consideration. And in the entire evidence, no question was put to the witnesses with regard to that the defect in collecting samples, it was section 52 was not followed. Nothing was put.
Issue was there.
No, nothing is there.
Defense.
Then let's say page 58 is the order of learned magistrate.
1 minute. এখানে সেপারেট হোসন হলে বহুটু
Paper book 1 lot.
এখন পেপার There are more paper books or what?
There are two paper books,
Two.
1 and 2. And
I was thinking,
combined
Huh?
class.
B1.
I've been supplied with two papers.
Only one?
One paper book, Lordship.
I don't know.
It is prepared by registry.
That's why I have provided two.
What is the other one?
Probably it may be continued, total,
Page 58.
let's say 2 copies have been supplied to.
50?
Page 58 lots. The order dated 6/12/2014.
Hmm.
Seizing officer Sri P.K. Dekar had produced inventory of goods seized, 29 packets of samples, case amount of rupees so and seized ganja with a prayer for perusing and seen. Inventory of goods seized 29 packets of sample, case amount and seized ganja are seen. Inventory were kept with CR and seized articles are to be returned to SO. LQ so. Then let's see page 123. Page 123 is the inventory of the goods seized.
Hmm.
So, and let's see on to clause 3. Place, date and time of seizure and detention. Detected on 5/12/2014.
In 2007, when it was not a notification. Sorry. 2007 or? Yes. Priority.
Place, date and seizure, time of seizure, detention. Detected on 5/12/2014 at about 4 hours from 2 trucks bearing number so at custom office at division Guwahati, formally seized the custom division office Christian Basti on 5/12/2014 about 12:30 hours. Then let's see on the top. Seen as the eligible chief judicial magistrate dated 6/12/2014.
Oh, yeah, there's 19. Yes.
I want to show page 123, the top clause. Seen as the eligible chief judicial magistrate Kamrup district Guwahati 6/12/2014. So the inventory was placed, prepared after seizure and.
Seen, not certified.
Yes, Lordship. No, I am not, this is not.
And
submission.
last column, remarks. Already drawn.
Yes, Lordship. I am not submitting that mistakes, samples were done in for the mistake in compliance of security criteria. My submission is that Lordship, samples were drawn in compliance with standing order 1 of 89. That is.
Yes, no doubt,
Yes, that is, I am not submitting.
as per clause 2.2.
Yes,
And clause 2.2 is exactly
at the time of.
was it issue in Mohanlal.
Yes, that is been considered by them. This is my humble sense. Lordship for.
What were exhibited? What were exhibited?
Lordship,
Let us see one by one.
Lordship.
In a judgment, last page maybe.
It is, it should be considered as Caesar list because Caesar list is not there in this case. PW5. Judgment.
See, page 120,
Inventory.
appendix of list of witnesses, list of defense witness nil, list of document exhibited, total 14, material exhibit 30.
Yeah, Caesar is believed. 2-1. Inventory. Signature to identify cases Caesar list is.
That list of samples were not there.
Sample for
See
forwarding.
the inventory sees.
I think that is the purpose perhaps. ABC, one is inventory certified.
Purpose of the.
And secondly, the photographs, I think, in presence of photographs, so that whenever if the main contraband was not disposed,
Cannot-
then if it is produced, then it can be compared.
There should not be any privilege or any change.
And any
Yes,
change
this-
or the nature of packaging, everything.
Yes, that's
So
why it is
that-
provided.
It should be taken in his presence. And third, that list of samples are to be drawn so that there should be some sanctity
There should not be any confusion with regard to there is any
and
allegation.
false implications, so
Yes,
that
that-
to remove the doubt of
Yes,
false
That
implications.
is,
Exactly.
for that purpose, it was introduced. With any-
Apparently, it is neither photographs,
It is not there.
certified inventory, these are the-
Nothing is there. That is admitted.
Caesar
Only-
list is not there. Lord.
2.2 was followed. That is,
followed, yes.
and my entire argument based on that was.
And that lined 31.1, no sooner.
No,
No,
sir.
sir.
My lord, as per list of these documents, Caesar list is not.
It has page 120 that there is two description of the same thing, inventory. If you read that part, one is exhibit 2, inventory, exhibit 2.1, Caesar list.
That is signature identified the witness as Caesar list.
2.1.
It will get at 123,
123.
123.
123.
So one will get that.
One, I don't know where it is.
One.
We have seen from 2.6 to 8, 2.7, 2.9, 2.13, 2.14, to 2.3,
Original.
2-4.
Original. Sir?
2.4,
Original.
2.2,
2.2.
2.15. That
It is-
R. Hazarika.
Yes.
It should be signature of
Original.
R. Hazarika, 2.1.
Yes, sir.
It is 212.
Informs. Good morning, madam. Close the door.
212.
S.K. Nargis. Learning Council for the Appellants. And Mr. S.C. Kyle. Learned Standing Council or
Yes, Lordship, specific, no, Lordship,
Standing Council? Customs. for the respondents. Arguments are heard. Judgment is reserved.
Apologies.